The Renters' Rights Act has been live now for 2 months, and the landlords who were most worried about the changes now have some initial answers of whether those fears were justified or not. What I'm actually seeing is most of the catastrophizing, which was quite a lot, hasn't actually come to fruition yet. But the changes that are quietly going to cost landlords the most amount of money aren't being spoken about enough. They're showing up in the numbers and the day-to-day mechanics of possession and rent increases, and the changes have materially changed what types of properties some investors are targeting. I've structured deals and helped clients grow portfolios through every regulation change in the last 6 years. And I genuinely think that this is one that most investors are underestimating, but not because the property market is going to crash, but because it's going to create a gap between the informed and professional investors to the unprofessional or accidental landlords. And this gap will show almost immediately in the net income of those property investors. So let's start with what's actually changed, because some of the commentary was pretty vague and a lot of it was talking about things that you don't actually need to be interested in as a property investor. The 3 main things you as an investor need to be aware of are the following. First, every fixed term in England has now become a periodic tenancy. This means it's a rolling month-by-month contract with no specific end date, even if it had one when that contract was initially agreed. The next is the big one, that the Section 21 no-fault evictions is a thing of the past. If you need or want possession of your property now, you need a Section 8 notice. This means that you're going to need specific legal grounds, and you might need to evidence this as well if the case gets to court. And the third and final thing is that rent review clauses in existing agreements are now void. All rent increases from May the 1st a couple of months ago now must follow a certain process with a Section 13 and a 4A form. This is a free government prescribed form, and it means that you must follow this process. You can't just swap it out for a letter or an email. It needs to be within this specific process and done in writing. To put the rent up, you need to give 2 months notice, and it can only be done once every 12 months. Those are the 3 changes that you as an investor should be aware of right now. And the one that matters the most for your numbers, you've probably not actually got a solution for yet. So what's actually happening 2 months in? Honestly, it's quieter than a lot of people had expected. Although some older landlords have got out, the landlord exodus that a lot of people were predicting has been a lot smaller and a lot quieter than people had predicted. Well-managed properties are still letting quickly, and rents are continuing to increase at the moment. The supply squeeze from unprofessionalised property investors that sold the properties are actually creating more opportunities for informed and professionalised investors. And although the overall outcome of the end of Section 21 is still to be seen, the widespread panic was probably a bit overstated. Most landlords that target quality assets actually never need it, and most of these tenants move on in their own time when they're ready. The landlords with the real problems here are the ones with problem tenants that are in consistent rent arrears and aren't paying the rent month on month. Section 8 was always there for this particular reason, and although some people would just use a Section 21, if it came to it, you would have to go through the court system anyway. But here's what a lot of the commentary actually missed. What's actually going to affect your back pocket isn't the headline changes. It's the possession timeline if something does go wrong, it's the risk around rent increases, and it's the standard of operation the new system requires. So let me take each of those in turn. First, let's look at the biggest one, possession. Under the old system, if a tenant stopped paying rent, you could serve a Section 21 with almost no real reason. It gave you a relatively clean route out, and you didn't actually have to prove anything, you just have to serve this correctly. Obviously, as we already touched upon, this route no longer exists. As of the changes just a couple of months ago, every possession now needs a Section 8 notice and clear proof to back it up. For 3 months of rent arrears, that's ground 8, and the court has to approve that if you can provide evidence. In a straightforward, uncontested case like that probably would be, then the likelihood is you'll get possession of that property within 4 to 6 months. And I appreciate that's not ideal because you would have missed out on a couple of months rent at that point. But the bigger problem is if this is actually contested. If this is contested or there's something else that's gone wrong and you've not been able to prove it properly, then this could take 9 to 12 months to actually gain possession of this property again. There used to be an accelerated procedure alongside Section 21 where essentially a judge could decide on paper without a court hearing, and that is now gone as well. So you're going to need a court hearing to be able to get possession of this property if they're contesting everything. So the problem with this, if you have a bad tenant, it's going to wipe out at least a year's worth of profit plus legal costs. The difficulty is that process does work, but in the past it has taken significant amount of time. And if people don't do Section 21 notices anymore, then the Section 8 notices are only going to increase. And does that mean that the waiting times increase as well? That's still yet to be seen. What I would say though is this process does reward compliant landlords with professional management in place because they'll move swiftly. Ideally though, the way to get around this is you get your tenant right at first. And this brings me on to my next point, which is something that you need to be conscious of if you're looking at buying right now. If you're looking at buying right now, or you're taking on a new tenant in the next month or so, you need to make sure that you've vetted them to a high standard. Obviously, vetting tenants has always been important because you want to make sure that you get this rent on time every single month. But it's even more important because Section 21 was your safety net against a bad tenant. That safety net is gone, so we need reliable tenants that pay on time and don't cause antisocial behaviour. We need verified income, stable jobs, solid references, and tenants that have a track record of paying on time every month. This isn't just best practice now, it's financial protection for your overall investment. Now, on the rent side of things, this one surprises more people. Putting rent up once a year was always the practice. Realistically, people weren't actually putting rent up more than once a year because rent doesn't move that fast. And if you're doing that, the likelihood is your tenants aren't going to be happy and you're going to be causing more headaches than it's actually worth. This means that Form 4A that's coming in is more admin discipline rather than a dramatic shift in what's happening day to day. The thing that has shifted in the last few months, though, is that tenants can challenge the rent increase through a tribunal. What this does mean is if any tenant does challenge this, your rent will be frozen at that level until a solution is found. Once this goes through the tribunal process, the tribunal will set the rent at a certain level, but this can't be above the rent that's been proposed by you as the landlord. The problem with this is that cases that go to a full hearing are likely to take anywhere from 6 to 9 months. So here's the practical picture. You serve a perfectly reasonable Form 4A and propose increasing the rent from £900 to £950 a month to your tenant. Your tenant then refers it to the tribunal. Even if you do win, which the likelihood is you probably will if you've got comparables and you've put it up to a reasonable standard, which the market dictates, your rent will stay at that £900 a month mark until a solution has been found. So on a £50 a month increase, that might be £300 to £600 that you're waiting on. That is delayed until this solution through the tribunal. It's not disastrous and you're not going to make or break an investment on this basis, but it's a bit annoying. And what it does mean is you need to provide comparable evidence when you're doing it. For me, it's all about communication. And the big thing is how you communicate that to your tenant, even with the form that you have to now provide. Make sure you have the comparable evidence, and it might even be worth you providing that to your tenants so at least they know where they stand and what that looks like. The thing I see most is that most commentary talking about the Renters' Rights Act actually misses one massive opportunity. And the main reason for that is they're talking to landlords who are scared about the Renters' Rights Act rather than investors that are still actively looking to buy property moving forward. Because vacant properties are now more difficult to get hold of, properties with tenants in situ are now being sold at discounted prices. Industry figures suggest that that is 5 to 10% below market value, but in practice, I'm seeing discounts significantly more than that, especially to investors that are buying in cash or buying with bridging finance and are able to move quickly. This is especially for older stock because that buying pool is then smaller again. But it's definitely not right for every property investor, especially one that wants to be specifically hands-off if they don't know anything about the tenants that they're inheriting. For the right buyer with the right plan and the right strategy who knows what they're getting into, then this is genuine below market value and equity at the point of purchase. But before you go ahead and try and do this, you need to get two things right first. First, when you buy a property with an inherited tenant, you need to find out as much about that tenant as you can do. You haven't chosen them and you've not vetted them, so you need to get as much information as possible. This means that the due diligence you do on the tenant is almost as important as the due diligence you're going to do on the property when you buy it. Things you'll want to know are things like how long have they lived in the property, are they consistently paying on time, what jobs do they have, and so on and so forth. This is because if a property is discounted because they've got a problem tenant, there's no point getting involved in that if you've never done anything like this in the past, because you're essentially risking your investment. And if that is the case, then you know exactly why the seller is actually selling that property. It's not because they want out and they've had enough, it's because they've got a property with a big problem tenant. The second thing you need to be aware of this type of property is if your plan involves doing work on the property, you need to be conscious of how long it takes for you to get possession of that property. This means that for buy, refurb, refinance and for flip property investors, you need to be conscious if you're buying a property with a tenant in situ, how long realistically will it take you to gain possession? And then you need to work those numbers in to your overall numbers. If you are looking for tenanted properties right now and you want a quick framework of what to look for when you're looking at these types of properties, I have put one in the description so you can click through that and follow this process that should make your life easier, and it should help you decide whether you should buy or reconsider a property you're looking at buying with a tenant in situ. It only takes about 5 minutes and it gives the property that you're looking at a score and whether you should buy it or not. Something away from this that I would be conscious of though is that you don't just have to buy a property with a tenant in situ just to get a discount. There are other ways to get good quality discounted properties in areas primed for long-term growth without focusing on this way. It is something we do at my business Frater. We focus more on vacant properties rather than properties with tenants in situ because we target new build properties direct from developer. But there are other ways as well, so just be conscious of that before you make a decision one way or another. So 2 months on, the picture is this. The doom hasn't arrived, but there are several things you need to be aware of that could cost you money if you're investing in property in the modern day. The possession timeline if the tenancy goes wrong, the tribunal risk on a rent challenge, and something that's always mattered but probably matters a little bit more now is the quality of the asset that you're buying and the reliability of the tenant that then rents that property. Well presented, well located, quality assets attract long-term tenants. You want tenants that stay longer, you want tenants that pay on time, and you want tenants that actually look after the property as if they had bought it themselves. Under the current framework, and something we've not yet seen change, it could take up to 12 months to gain possession of a property with a really difficult tenant, and that has a direct line into your returns, so be conscious of that. The investors that are going to look back at this change and still see success within property investment throughout the Midlands and the North are investors that prepared early and made sure that they were aware of all of the things that they needed to when these changes came in back in May. And if you're buying now, you need a clear, realistic view on what your plan is for that property over the next few years. If you want to look at what your situation looks like in the modern day with these changes, or you're looking to invest further and buy more properties in a way that's hands-off for you and your family, then I'll put a link to our website, Frater Property Partners, in the description. You can have a free chat with me directly. This chat is never about just showing you properties. It's about really understanding you and what you're trying to do. And if we are the right company for you, we can then put a plan together moving forward. But like always, I hope you found this useful and I'll see you soon.